This is the time and place for day 4 of the investigation 12-10-013 evidentiary hearings. I am Administrative Law Judge Kevin Dudney. With me is ALJ Melanie Darling. I'll be kind of the presiding judge this morning, then we'll likely switch roles again in the afternoon. Before we get started, I wanted to try and clear up what exhibits have been marked and received into evidence. So we have both marked and received exhibits A4NR 1 through 17. We have marked but not received A4NR 18. We have marked but not received CDSO 1 through 6.
What? Excuse me, what does not receive mean?
They have not yet been moved into evidence.
So is that something I explicitly have to do?
Yes.
Okay.
We have marked and received DRA 2, DRA 3, and DRA 6. Then for the Edison exhibits, we have marked but not received quite a few. I think we might work with the Edison team to relabel some of the appendices here. Sure. Hopefully we'll get that cleared up later today or first thing in the morning to have all the exhibits individually numbered rather than the number -A, etc. But we have Edison exhibits 1 through I think we have 1 through 25 marked.
Some exceptions.
There may be a couple exceptions in that list. We'll get that taken care of. There are also a couple of appendices, such as 3A there. Then lastly, we have marked exhibit turn 1.
And we'll put that on the record.
Yes, yes. We'll have Mr. Friedman introduce that exhibit this morning before we get started with Mr. Marcus. Okay, is that it? Is anyone?
Any questions?
Any questions on that? Mr. Giesman.
Would this be a time to move in A4NR 18?
I think that's fine.
I'd like to do so.
Are there any objections to accepting A4NR 18 into the record? Yes.
Not as to 18, but as to, there was a discussion we had, Your Honor, yesterday about 1 through 17. And Mr. Walsh and I had indicated that we had different records, that not all of them actually had been moved into evidence. 1 through 17, we indicated that we had some work we wanted to speak to Mr. Giesman about. He was going to review.
That's right. Did you have a chance to?
I have not yet, Your Honor, and I believe that the difference of opinion as to 1 through 17 is not whether they've been moved into evidence, but whether they've all been used yet or not. Okay. Am I correct, John?
That's correct.
Okay.
And I will consult the transcript, suggest any corrections that I feel are needed, and make certain that Munger Tolles and I are in agreement.
Okay. So by tomorrow.
And Mr. Walsh.
Yeah.
Mr. Walsh, I didn't mean to slight Mr. Walsh.
All right. If the three of you can take care of that sometime today, and we'll get that settled out tomorrow morning. Okay.
First thing.
First thing, yes. All right. Any other questions about exhibits so far? All right. Hearing none.
Go off to Mr. Marcus.
We'll go off until Mr. Marcus is here, or?
Mr. Marcus has arrived. He'll be in just a moment.
Okay.
Great.
So off the record.
Your Honor, we would like to call Mr. Marcus to the stand.
All right. Thank you, Mr. President. Mr. Marcus? Do you solemnly swear or affirm that all of the testimony you are about to make in this hearing will be true and correct to the best of your knowledge and belief?
Yes.
Thank you. Please give a business card to the court reporter and read and spell your name and business address into the record.
I'm fumbling for the business card, but my name is William Marcus, M-A-R-C-U-S, and my business address is JBS Energy Incorporated, 311 D Street, West Sacramento, California.
Mr. Friedman, please present the witness.
Thank you. Mr. Marcus, are you sponsoring testimony that has been marked as Exhibit Turn-1 titled Rate Making Service San Onofre Nuclear Generating Station?
Yes.
And was this testimony prepared by you?
Yes, it was.
Do you have any corrections or clarifications to make at this time?
No.
Is the testimony true and correct to the best of your knowledge?
Yes, it is.
And did the opinions contained in this testimony reflect your best professional judgment?
Yes.
And do you adopt this exhibit as your testimony?
Yes, I do.
Thank you very much. Your Honor, Mr. Marcus is available for cross-examination.
Thank you. Mr. Weissman, go ahead.
Thank you. Good morning, Mr. Marcus. My name is Henry Weissman. I'm an attorney for Southern California Edison.
Good morning.
I'd like to turn your attention to what's been marked for identification as Turn 1, your testimony, and ask you to turn to page 2, please.
Okay.
In part 2, you discuss the idea of a study of cash working capital for San Onofre specifically, correct?
Yes. Actually, I discussed the idea of including cash working capital for San Onofre specifically.
And your recommendation is that the Commission direct Edison to perform a study of cash working capital as it relates specifically to San Onofre, correct?
I think maybe I didn't explain myself perfectly. What I would suggest is that the Commission require Edison essentially to unbundle the authorized costs for San Onofre and use the existing parameters that were adopted in the last Edison general rate case decision for things like lag days for labor, for goods and services, for depreciation, and just produce a set of numbers for San Onofre that mechanically use what the Commission adopted for labor and depreciation and other O&M expenses and so forth, and the adopted lag days for each of those components. I think there's a lag day for nuclear fuel as well in there. But I wasn't envisioning Edison doing large amounts of new work. I was envisioning Edison essentially taking what it had from the rate case and unbundling San Onofre from the rest of it.
Meaning there would have to be an analysis of the data regarding, for example, in your example, lag days for payment of nuclear fuel.
There already is one. It's in the rate case. You use it.
And how about lag days for payment of PBOPs for SONGS employees?
There's one in the rate case. You use it.
You're saying,
could I interject real quickly, explain the term PBOPs?
oh, sorry. Pensions, post-retirement benefits other than pensions.
Yes, and all these lag day numbers exist in the rate case.
You're saying that in the rate case there's a specific lag day for these items that relates to songs as distinct from other operations?
No, and I wasn't expecting you to do a calculation of lag days for songs distinct from other operations. I think you're reading more into my testimony than I was reading, because I was just saying there are lag days in the rate case for basically everything that's in songs, and they're lag days for the company as a whole, but you can use them for songs. And I would point out also that SDG&E has zero working capital in their adopted rate case, so this issue does not apply to them.
So when you say, sorry, there's no line numbers, but on page 2 in the last paragraph, you say a specific analysis of songs needs to be done. Do you see that phrase?
Yes.
So if I understand your testimony, you're saying we should take the lag days for various categories at the company-wide level and apply them to songs.
Absolutely.
Okay. Turning to page 3, please. Here in part 3, you're discussing fuel inventory.
Yes.
And you note that Edison added $121 million to in-core inventory for Unit 2, correct?
Yes.
You also note there was apparently no reduction in pre-core inventory, correct?
Yes.
Have you had an opportunity to review Mr. Perez's rebuttal testimony on this point?
I have looked at it, but I probably need to check it again if you'd like me to think any more about it.
If you would be so kind as to turn to what's been marked for identification as SCE 8, page 4, line 21.
Okay. I see that I see what happened, which is that I relied on an earlier version of an Edison data request that they had corrected.
I didn't mean it as criticism. I just want to ask whether you have any reason to question what Mr. Perez says here on page 4, line 21 through page 5, line 2.
In terms of what happened, I have no reason to question it.
Okay, thank you. All right, turning to page 4, please.
Okay.
In section 4.
Yes.
In the first question and answer under part 4, you recommend that the commission either disallow replacement costs or remove base rate costs from rates, correct?
Yes, and then the base rate costs that I would remove are defined later.
Right. And the idea here is that this would be done on an interim basis pending further commission evaluation of the circumstances surrounding the outages?
I can say that from the point of view of what I had recommended regarding the specific base rate costs. And I think, and Mr. Woodruff is not here because his testimony has been deferred to a later phase, but I think his comments on replacement power would be similar.
Okay.
Can you just clarify for me, when you said replacement costs, are you only talking about power, or are you talking about the steam generator units, or what are you talking about?
No, in that one I was talking about replacement power costs. We should probably write the word power in there to clarify the exhibit, and I would make that correction.
Thank you.
Okay, and as you've heard, there's a little bit of a discussion about the scope of phase 1. So I just want to try to clarify the nature of your recommendation here rather than debate with you about it. It seems like you're recommending that one of these two categories of costs be removed on an interim basis pending an allocation of fault.
That is correct. And I think the first paragraph, the most important point in it, is that I'm saying you can't do both of these things at the same time for the same units of power.
Appreciate that. Okay, so may I have just a moment, Your Honor.
Off the record.
You say, except for costs already subject to refund in later phases, and you give some examples, costs before October 31 should not be removed from base rates, other than as reviewed through the memorandum account. So can you explain what you meant by that?
What I meant is that we have a fairly ambiguous songs memorandum account methodology that was put in place essentially in December in this last rate case. And there may be some true-ups, disallowances, and other factors that may occur through that account, which I am not speaking to.
I see. Okay, I am going to pass over then to okay. I'm going to pass over all the way to page 6 then. And I just want to clarify that your question and answer on page 6 is a recommendation that relates to Unit 3, correct?
You're talking about the recommendations on page 6 basically relate to Unit 3, I would say, in total.
Right. Okay. And the basis for this recommendation is what we talked about a moment ago, that we should take it, your recommendation is remove Unit 3 from rates because there's no near-term return to service prospect.
That's correct.
Okay. And in the second paragraph of this answer, you recommend that the Commission allow only 50% of the materials and supplies inventory and rate base?
Yes.
What's the basis for that recommendation?
Essentially, to take half of it related to Unit 3. The actual, what is actually in inventory, in some cases may be fungible between the two plants, but it's essentially to make an allowance for Unit 3.
Okay. Turning to page 7, please. And here on the top of the page, you make a recommendation about O&M costs for Unit 3, correct?
I think I may have a slightly different. I may have a slightly different pagination than you do.
Could we go off the record, please?
Off the record.
I'm sorry.
I was directing your attention, please, to page 7, top of the page. You make a recommendation about O&M, and this relates to Unit 3, correct?
Yes.
Okay. And this is, again, based on the idea that because there's no near-term return to service, it should be taken out of rates.
Yes.
Okay. Okay, moving on to part 5 of your testimony, which begins on page 7. You make a recommendation about what revenue requirements should be subject to refunds, yes?
Yes.
And again, this is pending further evaluation by the Commission.
Yes.
And this recommendation applies both to Unit 2 and to Unit 3?
Yes, it does. Although, obviously, if a cost is removed from Unit 3, there may be some mechanism to get it back theoretically, but it's not in rates.
Right. Okay. Please turn to page 8.
Okay.
And here we're discussing other accounting adjustments that you're recommending. And actually, let me skip over seismic and go straight to AFUDC on page 10.
Yes.
And here your recommendation is that the Commission order Edison to stop accruing AFUDC on capital projects in, you use the acronym CWIP. Could you define that, please?
That is construction work in progress. That's plant that's in the middle of being built and is not in service.
Now, AFUDC that accrues on CWIP has no current rate impact, correct?
That is correct.
So it's not been charged to ratepayers in 2012?
That is correct.
And it would only be recovered from ratepayers if the underlying capital projects are put into service, correct?
That is correct.
And in the interim, Edison is financing the capital costs of these projects in CWIP, correct?
In the interim, Edison is financing these costs, yes.
If songs were removed from rate base pursuant to 455.5, Edison could accrue a return equivalent to AFUDC, correct?
Yes.
So why should CWIP be treated differently?
Construction work in progress should be treated differently because there's a broader accounting rule than songs. Essentially, there is an accounting rule which is which I've laid out quite a bit of the information on, where it starts with SFAS 34 for generalized accounting, and has been applied not by everybody, but by FERC to some of its regulated activities and by a number of state commissions, to say that when a project is suspended by the utility, it cannot, when a construction project is suspended, could not accrue AFUDC. And we've had some dealings with PG&E on that issue in the last couple of rate cases on things like computer software and improvements to hydro projects rather than large nuclear plants. But it's an accounting principle that's broader than songs.
Okay, your answer, you refer to SFAS. Could you define that, please?
Statement of Financial Accounting Standards.
All right. So your recommendation rests on these accounting rules, correct?
It's a policy recommendation, but it is backed up with the accounting rules that I mentioned,
okay,
with some FERC activities. FERC has also said that you don't accrue AFUDC on abandoned plant.
Right.
And has said for some of its activities like pipelines that you don't accrue it on suspended projects.
We'll get to those precedents in a minute,
okay,
but I just want to focus just on the policy aspect of your recommendation. What is the policy rationale for denying Edison the ability to accrue AFUDC on CWIP and allowing it to accrue AFUDC on songs capital assets if they're removed from rate base? Why should those be treated differently?
What I would argue is that we have a statutory provision that says what we do with the assets that are removed from rate base. We have essentially a whole set of broad accounting rules and guidelines that deal with plant that is not already in rate base, but has been stopped for a period of time. I mean, I'm thinking that, Edison may have several projects at Songs 3 that it started to do, and then when it ran into this steam generator problem, it stopped them. I mean, this is a matter of fact that would be established later.
Right.
And I'm only speaking of things where the activity has been suspended because essentially there's no point to doing the activity until you figure out whether you can actually bring the plant back.
Right. I understand that. I'm asking you if you could, if possible, put aside the accounting standards and precedents, just focused on the policy rationale. Why should it be treated differently?
I would argue that it should be. I think you're asking me a very difficult question, because what I'm saying is that essentially the accounting standards are why it should be treated differently.
Okay, that's what I was driving at. Okay, so now turning to page 11, the top of the page, you refer to some FERC precedents here, and you talk about in the electric industry precedents on abandoned projects, correct?
Yes.
How do you define an abandoned project? Or strike that. How do you understand FERC to define an abandoned project in this context?
I would say that it's a project where there is no intention of moving forward and completing it.
Do the capital projects that are recorded in CWIP for songs meet that definition?
At this time, no.
If Edison were to stop recording AFUDC and the projects later were put into service, could the commission authorize Edison to recover AFUDC?
The first thing that we're talking about is a period of time, because you're talking about ceasing the recording of AFUDC during the period of suspension. If they actually start building it again, under all of these rules, they then get to start recording AFUDC again.
Correct.
And I believe that the commission would probably have the authority to do that. I wouldn't recommend that they do that, but I would believe that, the commission has, fairly broad rate-making authority. And I don't think there's nothing in law or regulation that says they can't do it.
There's no retroactive rate-making prohibition, to your understanding.
I'm trying to figure out what retroactive rate-making issue you're thinking about. Because I had written something about retroactive rate-making here, but I think it may be a different topic than you're thinking about. So if you could explain it a little better to me, I'll make sure we're talking on the same page.
Thank you. I'm taking the opposite of what you said. You said that there's no retroactive rate-making prohibition to directing Edison to stop accruing AFUDC, correct?
Yes.
And I'm taking the other point of view and saying if Edison stopped, would there be a retroactive rate-making prohibition to the commission authorizing it to recover AFUDC that had not been recorded at the time?
I don't think so.
Is there any harm to ratepayers to accruing AFUDC?
I would say there is, because then you end up in a position, and I will tell you about some examples from my first rate case, in 1982 test year PG&E rate case. And they came in that case and asked for construction work in progress in the rate base. And we went back through their accounts, and we found that there was construction work in progress on which they had been accruing AFUDC for almost a decade on abandoned plant. Actually abandoned plant. I mean, they weren't following the FERC rules. And in order to try to sort this out, and then they had these huge financial implications of when the commission in the next rate case forced them to write off the AFUDC, which and took that as some large financial consequence and complained about it. If it was never booked, problems like this do not occur. And I, even though I wouldn't agree with it, I believe the commission would have the authority to do something at a later date.
So your answer brings up an interesting point, which is if Edison does continue to accrue AFUDC, as it is now doing, and then later seeks to put the project into service, the commission would have the authority at that time to review whether and to what extent to permit the inclusion of the AFUDC in rate base.
I believe that is correct for putting the project in service. I'm more concerned with the flip side of accruing a bunch of AFUDC and then having the whole thing get abandoned.
Well, again, the AFUDC doesn't go into rates unless the commission approves it.
That's correct, but possession is 9/10 of the law under certain conditions, and people will argue about financial harm and hardship differently if somebody's trying to take $100 million of AFUDC out in one chunk than if it's suspended and we can look at it again if we're putting it in rates.
Okay, you mentioned that under, I think you characterized FERC's rules as requiring or permitting suspension of recording of AFUDC when a project is suspended. Did I get that right?
You're gonna have to repeat it. I'm sorry.
Sorry, let me break it down. You made some reference to FERC standards earlier relative to recording AFUDC.
Yes.
And could you recapitulate your understanding of those FERC standards?
My understanding is that FERC, the Uniform System of Accounts, specifically prohibits it on abandoned projects. I believe that FERC takes can take a case-by-case approach, and for gas pipelines, which are not the subject of what we're doing here, has reached the opposite conclusion, which is suspended projects do not get QIP.
May not.
May not. No, do not get QIP for gas pipelines. Which,
Well,
again, as I'm saying, we're not talking about gas pipelines here, but I referenced that as part of the policy argument.
But is there not a reasonableness inquiry by FERC in that context?
I don't know.
And does not that strike that, the FERC standard for pipelines applies when the pipeline suspends substantially all activities on the capital project, correct?
On a capital project, correct.
Okay. May we be off the record for just a moment, please?
Off the record. And while we were off the record, Mr. Shopson indicated he might have a few questions.
You can trade places with the gentleman next to you, perhaps.
Good morning, Mr. Marcus. My name is Mitchell Shapson. I'm the attorney representing DRA in this case. I want to ask you a question about something on page 4, the first question and answer.
Sure.
So I take it we can amend the testimony to say replacement power costs, correct?
Yes.
Okay. Are you aware of the commission ever disallowing replacement power costs?
In past history, the commission has done that on several occasions. I can think of some Songs 1 issues back in the 1980s, for example, and I think there were some disallowed because of an explosion at Mojave in 1985.
Okay, and what do you understand the policy reason behind those disallowances?
Essentially, because something bad happened that was found not to be reasonable and prudent. The ratepayers, for example, in that Mojave case, did not get all the coal power to which they were entitled and had to generate with oil and gas, and that amount was disallowed.
Okay, when you say, imprudence, and what was the other phrase you used?
I said imprudence or unreasonableness, which I think I may be being redundant.
Okay, and whether it's unreasonableness or imprudence, that would have been on whose part?
That would have been on the part of the utility in those cases.
Okay, thank you.
Yeah. Is there any other costs for Mr. Marcus? Do you have questions first?
No.
Yeah. All right.
No, it's Mr.
Oh,
Friedman.
yeah. Mr. Friedman.
Can I have a moment with my witness?
And off the record?
Thank you. Mr. Marcus, you were asked questions by Mr. Weissman regarding AFUDC accruals and FERC precedents. Do you recall those questions?
Yes.
Your Honor, I have provided Mr. Marcus with a copy of the FERC decision, the FERC order that is referenced in his testimony. And Mr. Marcus, I'm wondering if you could read into the record the two-part test that FERC has established for gas pipeline suspension of gas pipeline construction activities and AFUDC.
The commission said that it will allow natural gas pipelines to begin accruing AFUDC on construction projects when the following two conditions are met. One, capital expenditures for the project have been incurred, and two, activities that are necessary to get the construction project ready for its intended use are in progress. And then they have some further commentary on the definition of activities is to be construed broadly and can include some activities prior to physical construction.
And how is your recommendation consistent with that two-part test?
Essentially, what I'm saying is that we don't have, when you suspend a project, you don't have activities necessary to get the project ready for its intended use in progress.
you. And just to clarify, you were asked questions early on in the cross-examination about cash working capital. Can you just explain how cash working capital is calculated as a general matter and why? We'll start with that.
Okay. Cash working capital, there are a number of components, only one of which is relevant here to operational cash, and the one that's relevant here is prepayments for insurance. And then in addition, there is a lead lag study conducted, and a lead lag study basically says, does the utility need money faster than it gets it from ratepayers? And they get to put that in rate base. And the lead lag study divides the utility's costs into a large number of components: labor, goods and services, depreciation, which gets a zero lag, income taxes, property taxes, deferred taxes, which also get a zero lag, those types of things. And these issues tend to be decided in rate cases, and then you plug in the amount of money the utility has for labor or post-retirement benefits other than pensions or depreciation, and you create a table, and then you calculate from that process an amount of rate base. And some of Edison's labor authorized in its last rate case was for songs. Some of its PBOPs was for songs, because that probably follows labor. There's clearly a songs depreciation number. The income tax for songs might be slightly harder to calculate, but it's probably calculatable without a great deal of difficulty, because a lot of it comes from the fact that they're earning a return on it. So essentially, with the possible exception of income taxes, there are pretty easy calculations to figure out what the authorized cash working capital is for songs.
Great. Thank you. I think those are all my redirect questions, Your Honor.
Just very briefly, Your Honor, Mr. Marcus, of the projects that are currently in CWIP for songs, which of them have C-stall activity?
What is C-stall activity?
Well, I was just trying to track the words I thought you used from the FERC decision.
I didn't use the word C-stall activity.
Okay.
I'm sorry.
Let me restate the question then. You said that the second criterion was that activities necessary to get the construction project ready are in progress, right?
Yes.
And later on paragraph 38 of the same decision, it says that if the pipeline suspends substantially all activities, then it should stop unless the company can show that the interruption is reasonable, correct?
Yes.
So my question is, of the projects that are currently in CWIP, which of them has Edison suspended substantially all activities?
I don't know. That's a factual question. But I think that if you're looking at projects where the critical path is to get the steam generator back, and you have suspended activities on them while you're waiting to get the steam generator back, like PG&E suspended activities on computer projects while waiting to get another suite of systems in, then those projects should have AFUDC essentially pushed back. Now, my comments here are saying if the steam generator is critical path, then substantially all of them would be under some type of suspension. If Edison can show otherwise for specific individual projects, that might be appropriate at a later stage of this proceeding.
But you don't know as a factual matter whether work has been suspended on which projects, correct?
No.
So turning back to page 10 of your testimony, turn 1, when you recommend that the Commission order Edison to stop accruing AFUDC on capital projects currently in CWIP, you see that?
Except that I wrote that been suspended due to the need to address steam generator problems first. I wrote there's a qualifier in there.
Right.
And I'm saying I don't know which things fall under that qualifier.
Very good. That's what I wanted to clarify. Thank you. I have no further questions.
All right. Thank you, Mr. Marcus. I think you're excused.
Thank you.
Your Honor, at this time, I'd like to move Exhibit Turn 1 into evidence.
No objection, Your Honor.
All right. Hearing no objections, granted. And off the record. She's outside. Let's take about a 10-minute break, and then after we resume, we'll bring up Mr. Palmisano and start with Ms. George for further cross-examination of Mr. Palmisano. So,
Followed by Ms. Fenskis.
Yeah, followed by Ms. Fenskis, and hopefully that will take us roughly to lunch, and we'll go from there. So please be back ready to go at 10:30, and off the record.